Okay, got it. Good morning. This is Thursday, February 10th, 2022. And just for Vermont Digger who are watching in, I got the date right today. There was a little comment, Digger, about yesterday when I said, you know what day it is. So let's, we're starting with markup of S265. And Ben, I didn't get a chance to print. Do you want to start out by, unless there's some comments from anybody, start out by printing out the latest draft that you worked on? Not printing out, but walking through the latest draft.
Sure thing. Ben Novogroski from the Office of Legislative Counsel, and I'll go ahead and share my screen. Everybody see you?
Good.
Yeah, I'm fine. I'm going to shut off my video.
So can everybody see the latest?
Is this draft 3.1
Yes,
of yesterday?
correct.
Oh yeah, there it is. Okay.
So in draft 3.1, what we've done is updated a few sections to cover an attempt to cover situations like Senator Sears had indicated for violations of public health orders or a situation potentially like Slate Ridge. And this is in what is labeled as subsection E. This reads, a person who violates subsection A of this section with the intent to impede, intimidate, interfere, or prevent a person from complying with state laws or rules, state court or administrative orders, or state executive orders shall be imprisoned not more than 3 years or fined not more than $5,000 or both. So what this subsection contemplates is if an individual or business owner is if a true threat is levied against them for their compliance with, say, a mask mandate, or if there is a court order to stay away or to cease an activity, and there are threats that are made for complying with that order, this is something that would criminalize the threat to make to comply with. This would criminalize the threat to try and impede or intimidate the person from complying with one of those orders. And based on the committee discussion, the penalty would be 3 years or a fine of not more than $5,000 or both. That can be adjusted depending on what the committee decides. Is there any questions on this section before I move on to another change?
So they have to. Can I ask questions, Senator Sears?
Yeah, sure.
So, so say a person comes to a store and there's a mask order in place, and they get into an argument with the store owner about wearing a mask. They could be fined. They could come under this.
Well, it depends, which is, I know, sort of a frustrating answer a lot of the times, but if the argument and the context became a true threat, meaning one that engendered real fear, it was a serious threat. This is not intended to cover arguments. Our First Amendment protections really do protect debate, some pretty crude language, but if it rose to the level of a true threat where someone really feared for their life or serious bodily injury, then this is something that could fall under this section.
Okay, thanks.
I kind of like it to, if somebody says, I'm not going to shop at your store anymore because you're enforcing the mask mandate, that's not a real threat. I mean, it's a threat, but it's not a threat of serious bodily injury. But if they say, if you are going to require a mask, I'm going to blow up your store, that would be a threat of serious bodily injury or death.
But potentially, I mean, it really needs to have
really
a
depends on
firmness
the
of
individual.
purpose.
Yeah.
I'm happy to move on unless there are other questions.
No. Are there other questions about that section? Okay.
If you see in what is now subsection F, subdivision 3, the highlight here on lines 14 and 15 excludes correctional facilities from the definition of public accommodation as it's defined in 28 VSA section 3, subdivision 3, subsection 3. And I know in the last time that the committee held testimony on this, there were some other approaches to either enumerate specific places. This was just chosen sort of as a starting ground, or if this is the committee, if this is the committee's chosen approach, it could be done this way as well. But there are other approaches where you could really enumerate the specific places that are that an enhanced penalty would be appropriate. And some of those, if the committee would like to hear, and this is based off of the communication I had sent you earlier, is that you could really enumerate that it could be a public or private school, a post-secondary education institution, place of worship, polling place during election activities, the Vermont State House, or any other federal, state, county, or municipal building. And state, county, municipal building would not include correctional facilities. And a polling place is defined, and there would be a cross-reference in the to the proper section of Vermont statutes. But right now, this is just keeping the place of public accommodation with the specific exclusion of correctional facilities.
I'm kind of troubled by it because it says basically it's okay to threaten corrections officers or threaten another inmate.
I don't remember where that came from.
Came from Matt Valerio.
Okay.
Wanted,
Well, the in Senator Sears, if I may, what this would do though is exclude correctional facilities from that enhanced penalty, because what remains unchanged in this version is in subsection D, that placing someone in reasonable apprehension that death or serious bodily injury will occur at a place of public accommodation shall be imprisoned not more than 3 years. So that remains, and what this does is exclude correctional facilities from that. So threats, threats made in correctional facilities would not be subject to the enhanced penalty.
Yeah.
can I ask a question also?
Yep.
Yes.
Yes.
Quite frankly, I don't know. Back down a little bit, Ben, slide it back down. Oh, the other way. Up, it's up, sorry.
It's okay.
What
Subsection D.
political subdivisions, or what are political, in the,
So a political subdivision would be really any sort of entity of the state. Political subdivision can be state government, it can be state agency, anything that kind of acts with authority derived from the state. So that's.
would there be a better way to say that so that people don't think that politics is somehow involved here?
Well, political subdivision is used. I mean, that is the term for.
Person on the street knows that.
Well, the person on the street knows it in connection with every other bill that we ever do around political subdivision, like open meeting laws and public records and all of that.
I don't think they read those.
No, that they
Senator-
don't read those. I'm not sure they'll read this either.
They might read this one.
Senator Nick, so you're referring to subdivision 5 of section F, subsection F? Okay. Yeah, I mean, so the public employee definition is just to make sure that everybody is covered that could work for, that is an employee of the state, or county or local government.
And wouldn't it be better to include, if it covers schools, not to specifically mention schools? I don't know.
That's a
Well,
political subdivision.
Yes.
I get it, but
It could be explicitly mentioned if that's something that you'd like to see.
I think if it's covered, it perhaps should say it.
So Ben, can you remind me where public employee and election official is used here?
So if you,
I looked
understand
at this last night, but I didn't
So
print it out, unfortunately.
Sure. So it's in the new
Oh, yeah.
subsection F or H, excuse me. And it reads, a person who violates subsection A of this section with the intent to influence the conduct of a public servant, election official, or public employee relative to the public servant's, election officials, or public employee's respective position, or with the intent to retaliate against a public servant, election official, or public employee for previous action taken relative to the public servant's, election officials, or public employees' respective position, shall be imprisoned not more than 3 years or fined not more than $5,000 or both. And I know that is a wordy provision, but really that's just to maintain some drafting conventions and non-gendered language, just to truly effectuate the substance of the provision. So basically what it just says is that if someone's true threats are aimed to influence the conduct of a public servant, election official, and it includes one of their responsibilities or duties that they are supposed to act on in their jobs, or if it retaliates against something that they did in their jobs, it can be criminalized by imprisonment of 3 years or a fine not more than $5,000 or both.
Senator Sears, may I ask a question?
Sure.
So one of the things that Rory talked about was that there's a significant risk that threats will disrupt government operations, but this doesn't say anything about disrupting the operations or impeding the ability to function. This just says that it's influences the conduct of the public servant. So the influence could be that I want you to not count these ballots, but that doesn't necessarily disrupt. And I thought that's where we were going here with the disruption of government operations.
Well, I think not counting the ballots would be a disruption.
It could be just aimed at that one person I mean, I don't know.
Could be aimed right at the Secretary of State or some other election official.
Well, and Senator Sears, if I may, Senator White, I mean, that's a valid observation, but with this is drafted in such a way that it would still be constitutional, because these threats have to be aimed and have to have a certain specificity to express that gravity and seriousness of harm. But I do think that this would cover the conduct or operations of government, if you will, because it's really aimed at what public servants, employees, or election officials are doing in their job. So for instance, counting of ballots, if there was a threat made that was serious enough that affected an election official and prevented them from counting ballots because they were in fear for their life, it would cover that. So we're kind of balancing those interests of ensuring the constitutionality of the language to keep it specific enough against individuals, but also relative to their professional duties, which oftentimes do affect the operations of government.
Yeah, I do get that. If somebody calls me and says, if you vote for that bill, I know where you live and I am going to shoot you and I'm going to shoot your children. That doesn't necessarily disrupt anything because I'm only one person out of 30. So, but anyway.
Ben, can I ask a question?
Yes, Senator May.
So if a very angry, loud group of people is standing in front of the Enterprise Hotel in Washington, D.C., yelling, hang Mike Pence if he decides to count the ballots,
Quite a chant.
and start chanting that, am I correct that those people, by that loud, obnoxious set of words, is now in violation of this?
I would say they're not. And the reason why is because a lot of the true threat doctrine is dependent on context. And there's this distinction within the First Amendment between the allowance of political hyperbole and the prohibition of true threats because of the lack of social value that they hold. And political hyperbole, for instance, there have been Supreme Court cases in the Watts case, for instance, that we've talked about before. That was done in a protest type setting. And the statement in that case was, they always holler at us to get an education. And this was in the context of the Vietnam War and the draft. Now I've already received my draft classifications as a 1A, and I've got to report for my physical this Monday coming. I'm not going. If they ever make me carry a rifle, the first man I want to get in my sights is LBJ. And that was considered political hyperbole. And it was sort of the court reason that was the kind of crude, offensive method of stating political opposition to the president. So I think in your example, it would probably fall more in the political hyperbole context rather than a true threat context, because there's this environment of protest, of anger, of passion. And that's part of the analysis that the court does in making the distinction. So I don't think that this language in subsection H would cover that situation. It would be permissible. I think it's when it's much more specific and expresses the gravity of the situation, and it's repeated or really is directed at someone specifically in a more personal way, is when it crosses that line into a true threat, which would then be covered by subsection H.
But the perceptor is Mike Pence. And would not a court review Mike Pence's perception and place in front of a jury or a trial judge the question of whether or not Mike Pence reasonably felt under threat?
It's possible. However, the court would do that analysis, and I think, again, I qualify it because it always depends on the specific facts. But since it wasn't really specifically directed to him in a more direct or more imminent way, it probably falls outside of it. I think the court would probably do the analysis anyway. They're probably obligated to. But the intent of this is to strike that balance where it's truly a true threat as opposed to political hyperbole. And I think in the context of a protest, a lot of times that lends itself more to political hyperbole. Not always, because it's always fact dependent, but they may inquire with Mike Pence if, depending on the facts. But I think that that's conduct that would probably be left out from being criminalized under the statute.
I guess I'm expressing concern because it appears to me we are removing any nexus between actual actions and spoken words. We've crossed off any kind of an affirmative defense. And certainly in hindsight, the angry group of people at the enterprise, they eventually followed through with their threat by marching down the street, but that's not, I guess I'm not reading this the same way as you are. That just maybe.
I thought that in terms of the affirmative defense, we eliminated that from the language. Doesn't mean that somebody couldn't raise the defense. That was what was the suggestion of the Defender General, that we remove that language and be silent on it, rather than saying it is an affirmative defense or it isn't an affirmative defense. We're silent. So they could raise that issue. That was my understanding when we agreed with him on that, or if we agreed with him. I don't even know if we've agreed with him, but we decided to strike that section in this draft, and that was a general consensus. So I think it's still there. You can still argue an affirmative defense. I don't think we've struck the ability to have an affirmative defense.
I guess my concern is the overall impression that we are now using words, as horrible as the words are, and analyzing the words through the recipient of those words, and then setting up a court case to determine whether or not the person who received those angry words or heard those angry words was reasonable in their understanding of whether they were threatened. I got to float out there that concerns me.
And
Well, it concerns me that public officials and others are put in positions where making a determination in what they believe is in the best interest of the majority of their constituents, or in just being of a certain color, results in their being attacked and their ability to continue either in office or to continue to do their jobs. And that was, quite frankly, the motivation behind this bill, was the threats that election workers were receiving in Vermont from some people in Vermont and some people outside of Vermont, even though Trump lost by a huge margin in Vermont. There was still allegations of corruption, of, the big lie, etc. And then there were those phone calls that we've all had access to election workers. There's also been, James Lofton talked about the situation with his wife and her decision not to seek elective office again. I just don't think we can suggest that these, whatever term you want to use, are acceptable when they get to the point where they put somebody in fear of death or serious bodily injury to themselves or a family member. I've got some problems with other sections of this bill that I'd like to discuss, but I just think we've gotten to a point in this state and in this nation where we need to take some action. We need to say, this is not acceptable. And to provide a heightened penalty, to me, in these particular cases and some others, I'm not sure we're getting where I wanted to be personally, but I can live with this. To me, to have a heightened penalty when this is impacting democracy, frankly.
Dick, I want to be clear. I don't disagree with you that every appearance is that there is a line that has been crossed. And I've listened to the phone calls that were sent to me from the Secretary of State's office. What I struggle with is where the line of demarcation between hyperbole and the decision of an individual on the receiving end of that hyperbole now becomes the basic building blocks of a felony charge. And I'm running into my own observation of what the First Amendment is supposed to be about, trying to balance that. And I'm struggling with this bill as a result of that. But I don't want to leave the impression that I'm minimizing the impact that some of this language that's been spoken has been having on people. And I just don't want to leave that impression with anybody.
It's having the desired effect, I would say.
So may I ask a question?
In some cases, I want to be clear, just before you do, what I just said was it's having the desired effect. We have election workers who are going through PSTD as a result of some of these threats. We have cases where people have chosen not to run again for public office because of these threats. We have cases where, so that was evidently the desired effect of making these threats. And so are people comfortable doing their jobs? I mean, I look at, and I realize that many of them weren't in Vermont, but I look at some of the intimidation happening in school boards in Vermont based upon mascots. It is not a pleasant time to be in public office in many cases. And I think that, that's what, when those of us who introduced the bill felt enough is enough, and we need to make some changes to the criminal threatening statutes and move more towards the federal standard. That was the whole thing here. And I think, so I'm comfortable with moving towards a federal standard. We're not, and I believe that's what we're continuing to do. And that, you look at Rory's document, this document here, I think clearly, I think moving towards a federal standard isn't exactly a bad thing. Anyway, I'll continue to, I understand where you're coming from, Joe, and I'm not unsympathetic to what you're saying, but we're still moving towards a federal standard. Is that correct, Ben?
Yeah, Senator Sears, it does incorporate language and from some of the federal statutes. It still is different because we specifically name public servants, election officials, or public employees. Theirs talks about judges and legislators, but it's similar I think in that sense. And another thing that I'd be remiss if I didn't mention is this is all analyzed through an objective standard. So, Senator Benning, what you had said before is that would they kind of go by what Mike Pence was feeling? It would really be what a reasonable person would conclude as threatening. And so it's not really subjective. So the standard is whether the recipient of a defendant's allegedly threatening behavior perceived that behavior as a threat, but if it was objectively reasonable. Some people are more sensitive than others. And so I don't know if that helps with the understanding a little bit that it is this objective, reasonable person standard that it's viewed through.
I understand the argument, Ben. I have a remaining concern, and I'm not sure how to bridge that, but I don't want to lengthen this conversation. I think I've stated my piece, and we'll continue to move on.
Let's see, we're down to H. We discussed that. Can we go back to section 1, E.
1E.
On
Yeah,
page
on-
2, lines 3 through 7.
Yes. What does this, where does this put a reporter, for example, who reports on the phone calls to the Secretary of State's office, does some investigation that, and leads them to who that person is, or at least where they're from, and then receives threats for having done that? Are they out of this?
Yeah, subsection, in that situation, I wouldn't say subsection E would apply. This is really aimed at compliance and threatening behavior for following state laws, rules, court orders, administrative orders, or executive orders. I think in the situation that you gave with the reporter essentially doing their job and potentially being threatened for that, that would probably fall into the general provision of subsection A, which would be a threat to a person or a group of particular person, and then that it would place the person in reasonable apprehension of death or serious bodily injury. Or if it was done in a place of public accommodation, if the threat is that it would occur there, then it would potentially have the heightened penalty of subsection D.
Okay.
May I ask a question about
Senator
that?
White, yeah.
So I'm still confused about why, if we have E, and which it takes care of the mask mandate interfere or whatever, and we have H, which applies to people carrying out their duty. Why do we need C? Because I'm still concerned that, D, that is so broad, and I don't know what it means. If I say that I'm going to go shoot somebody, I make a threat to Joe, and I say, I am going to shoot you, and I know that you're going to be at Pete's Pub tomorrow night, and that's where I'm going to shoot you. Just because I shoot him at Pete's Pub, there's an enhanced penalty, where if I shot him at his house, there wouldn't be. I don't get why we have this in here if we have E and H.
Well, Senator White, I think that ultimately comes down to a policy consideration for the committee as to how far you want to go. My approach with this amendment was just to add language so that you could see how it would interplay with each other. And then if you wanted to make further amendments from that, that is completely your prerogative. But yes, this would be subsection D, in addition to the others, would still criminalize that situation. If it occurred at a place of public accommodation. I think the intent in drafting this was to cover, schools and places of worship and things of that nature, where there could be threatening behavior that's been made in the past that, potentially may not have been prosecuted because of the gap in the law. But again, that can be remedied in another way through enumerating those specific places, which I know State's Attorney Tebow had suggested in previous testimony.
Okay, thank you. That was, thank you.
Okay. Maybe it's time to see if there's any comments from people in the audience, and I can't see them because I'm hidden by the.
Senator Hughes, would you like me to stop sharing my screen? And
yeah, why don't we go to a gallery view and get some comments if that's helpful. And I think Harrison Stark would like to speak first, and then anybody else, Rory be next, and anybody else who wants to.
Thanks so much, Senator Sears. Again, for the record, Harrison Stark, I'm an attorney with the ACLU of Vermont. In this conversation about walking the line between political hyperbole and true threats that actually interfere with the workings of democracy, I do think that the committee is trying to thread a fairly fine needle here. And I do have some concerns that the bill as currently drafted and just containing an enhancement to influence the conduct or decision of a public official does cut fairly close to legitimate First Amendment petition concerns. I mean, I think that the core of First Amendment political speech in many ways is the ability to influence the workings of government and have an input into particular decisions. And I think that a potential middle ground, which may be helpful here, I think is actually the language that Rory submitted following the hearing earlier this week. And the language that he suggested was a little bit more specific, and I think takes us away from quite close, how close we are to the line of legitimate First Amendment concerns. And so the language that he proposed was a person who violates subsection A of this section with the intent to terrify, intimidate, or unlawfully influence the conduct of a public servant in any decision, opinion, recommendation, vote, or other exercise of discretion. And I do think that gets closer to the sort of illegitimate, unprotected threats that would actually coerce a government official into unlawful action. I think that's some safer language that gets us a little further away from just the ability to unlawfully, not even unlawfully, just to influence the conduct of a public official. Because I share your concern, Senator Benning, that does bring us fairly close to the line in that I think any public official receiving a threat will see it as an attempt in some ways to influence their conduct. And I think that the terrify, intimidate, and unlawfully influence in this particular exercise of discretion that Rory suggested may be helpful here.
Thank you. Rory, do you want to comment?
Good morning, Senator Sears, and for the record, State's Attorney Rory Tebow in Washington County. So I like the way that Mr. Stark described that the committee really is trying to thread a needle, and it's a fine line to not have a statute that's overbroad and that will survive a challenge. I want to give a little bit of insight into the language that was structured and as he just read into the record. That borrows in part from our disturbing the peace by electronic means, which has along the laundry list of intent elements with it, the intent to terrify, intimidate, and then the remainder of that borrows from the model penal code, looking to what is the effect or how do you demonstrate some sort of unlawful intent or action on a public official. The other analogous charge that currently exists is really geared towards judiciary, which we mentioned before, which is obstruction of justice. And that's when conduct endeavors to impede the due administration of justice, or it does so, in fact, by threatening a juror, a judge, a witness, or someone in that process. So I think that this really rationalizes threats directed towards executive or legislative members of government in a way that I think would be constitutionally sustainable and would hold up. But I would echo what Ben said before, which is there's a lot of policy choices on the table here for the committee. I don't have necessarily a firm recommendation which way the committee goes, but want to make sure that there are options out there. And the ultimate goal, of course, is I think to protect employees, protect people in the community, but also ensure that we're doing so in a constitutionally sustainable manner. The other point I wanted to make to Senator Benning's earlier comments, I think it's important to note that while the threat may be directed towards a particular person, there still has to be a finding for both probable cause and a trial that it caused reasonable apprehension for serious bodily injury or death. So there is a reasonableness standard there. So I don't want to say that if you have someone who's hypersensitive, we're not just going off of a singular perception. It has to be some legitimate, I think, basis for that. Ben also walked through some of the case law again about true threats. And when in one of the slides I presented previously to the committee, the true threats doctrine has a number of sub-elements to it. Part of it is the volition, the sort of immediacy of threat or harm, which is a subjective analysis. And I think that's what makes a lot of this difficult to legislate, is that defining this in a statutory standard is difficult because so many of these cases are fact and circumstance specific, which is why we still have to lean on both federal and case law in terms of making charging decisions and actually sustaining this in a trial setting. But again, I think there is great merit in aligning Vermont's laws with where the model penal code already is, and as other states have adopted, and certainly the federal standard we've made reference to. So I appreciate it and available for any comment or questions or other comments.
So could I ask a question? This
Yeah.
becomes a felony. And I just wonder what the collateral consequences of a felony are. And if somebody at age, I don't know, 22 gets a burr and decides to become very threatening, and at the age of 35, and then is convicted under this, and at the age of 35 has grown up, I'm using that in quotation marks, and realizes how stupid he was at age 22, he still has all the collateral consequences of having been convicted of a felony. That means he can't go hunting, he can't, there are certain professions he can't go into. So I am somewhat concerned about how this would impact somebody's future life, since it is a felony. And I'm not excusing the person who did it at age 22, but I am wondering about the impact that it will have on his or her life when they grow up.
So Senator White, a few things to note, that right now criminal threatening, and even with the enhancement, this would not be, or has not been suggested to be added to the set of listed offenses. So it remains a qualifying crime subject to both sealing and expungement after the appropriate statutory period. When you are talking about someone who's under, a young age, under Title 33, we still have the ability for sealing of records for younger adult individuals. Those are protections. And I also note, although it's not commonly used in the state of Vermont, Title 13, Section 8011 deals with the restoration of rights. So there can be issuance of a certificate of restoration of rights upon petition to the court. So even if a case is not sealed or expunged and that collateral consequence remains in effect, someone can petition the court to demonstrate the rehabilitation is achieved and request to be relieved of certain collateral consequences under law. So with that said, I think so long as Vermont maintains, I think, a fairly forward-leaning sealing and expungement regimen, particularly on the end of expungement for the ability to restore those rights, there is some safeguard, particularly when you have a anomalous, if we call it a one-time anomaly, or someone acting at once in relative youth, a sustained period of no additional convictions really paves the way for a compelling argument to have that record either sealed or expunged, or again, even notwithstanding that, to seek a petition to restore such rights. So, and I think that's an important point, really, not just in the context here for criminal threatening, but in a lot of laws, that there are avenues for people who are successfully rehabilitated to overcome those impediments. And that's something that I'm happy to see that really all partners and stakeholders in the criminal justice system have generally embraced.
Thank you.
That's helpful. So going back to Ben, if we could, a couple of the issues, you don't need to post the thing. I'm more comfortable with the suggestion from both Mr. Stark and Mr. Thibault in terms of the wording. I think it's a good suggestion. It's just personally, I'm not speaking for the rest of the committee. I remain concerned about correctional facilities being exempted, and what that's saying, quite frankly, to inmates is, so it makes it okay to threaten another inmate. And I'm sure I understand that they could be covered under section, under the non-heightened penalty, but I'm concerned that we're singling that group out as it's okay. because it's how it's going to be perceived. As Senator Nitka points out, it's how the average person reads the law. And if we're doing all government agencies, I don't understand that particular decision if we do that. So I'm opposed to having that excluded unless we list places rather than using public accommodation, and then we list places and we didn't include some places. That would be a little different, I guess. But the perception of just having out there place of public accommodation does not include a correctional facility. It's troubling. I know where that came from, and so the Defender General is here and can speak if he'd like, as is Steve Howard of the VSEA, who obviously has a difference of opinion.
You want me to go?
Yeah, if you'd like.
Okay. Matt Valerio, Defender General. My comments regarding that were in the context of the discussion that was going on at the time about whether or not this should be focused on public accommodations or some other thing. You talked about this list issue before. Within the Department of Corrections, there is already a disciplinary structure for threats with disciplinary referrals, and there's already the ability to deal with threats as a misdemeanor. And one of my biggest issues with this bill, there were two big issues. One I think has been resolved, and that is that the I don't think the legislature should prescribe the defenses that are available in statute, and that should be left to the court, and that seems to be addressed. And the second is that creating a 5-year felony, and I don't understand, I still fail to understand what is gained by a 5-year felony as opposed to a 2-year misdemeanor. I don't know what you gain from either from that. So to me, if it's going to be a felony, it needs to be limited to particular areas of concern. If it is, it could be broader if it was stays as a misdemeanor. I don't see I understand what people are concerned about, and what I don't understand is why existing law is not used to address the issues that are out there. That having been said, the committee seems intent upon going forward with this, and under those circumstances, as long as the court is there to determine what defenses are available, I am not. I still have an issue with as a felony, and if it's a felony, it needs, to my view, it needs to be limited. But that's the basis for my thinking on this.
Okay. Thank you.
Mr. Chairman, may I add to that?
Sure.
Thank you. For the record, Steve Howard, I'm the Executive Director of the VSEA. The VSEA agrees with you and strongly believes that there should not be an exception for correctional facilities. Correctional facilities are some of the most dangerous work sites that we have members working in, and threats against our members are common. They are terrorizing, they are demoralizing, and they are frightening. And frankly, I disagree with the Defender General that the consequences for that should be reduced or limited in any way. I think they should be broad. I think they should be very substantial because people should not be threatened. Their life shouldn't be threatened. Their family shouldn't be threatened just because they're doing the job that they were hired to do by the state of Vermont. So I hope that exception for correctional facilities will come out. I hope it stays a felony, and I hope it remains as broad as possible.
Okay, thank you. The other way is to list But I'm okay. Our Senator Nitka.
See what the list would look like? Does Ben, do you have that list available?
I do. I can actually share my screen. I just updated my draft so that you could take a look at the list that could be added. So if you just bear with me 1 minute, I'll share my screen again. So subsection D would now read, person who violates subsection A of this section by making a threat that places any person in reasonable apprehension that death or serious bodily injury will occur at a public or private school, post-secondary education institution, place of worship, polling place during election activities, Vermont State House, or any federal, state, or municipal building shall be imprisoned not more than 3 years or fined not more than $5,000 or both. And then if this were added, there would be some definitions added to subsection F to define state, county, or municipal building, and polling place. And state, county, or municipal building, we could create as the committee could create its own definition, or I mean, to either exclude or include correctional facilities, because they would be considered state facilities within that, unless there was a carve out one way or the other. And then polling place would have the same meaning as 17 VSA chapter 51 subchapter 4, which is essentially any place where ballot counting or things of that nature would be going on during an election.
Okay.
Okay with me.
But as far as the breadth of federal, state, or municipal building, that's, I suppose, a policy consideration as far as how it would apply to correctional facilities. And it would still be a felony just of 3 years, as opposed to the 5. And that penalty has been changed throughout in this draft. So it would still be a felony, but just not just one for a shorter term of imprisonment.
I'm fine with any of that. As I look at the current law, it's currently a 1-year misdemeanor or $1,000 or both. So you could make it a 2-year misdemeanor and some other amount for a fine. You have that in C when a person violates the section with intent to prevent another person from reporting to the DCF the suspected abuse or neglect of a child. That's a 2-year misdemeanor.
Uh-huh.
If that makes people more comfortable to not have a felony, we could do that as long as we're using the standard that is applied in that Mr. Stark and Mr. Thibault described.
Could I comment on that?
Yeah.
I am more comfortable with that because, and I don't think that when people are doing this threatening action, that they're actually saying, oh my goodness, I better not do this because this is a 3-year felony. And we know very well that, for example, the death penalty does not prevent, it is not, as some people would like to say, that if people think they're facing the death penalty, they'll be more careful and they won't commit the crime. But we know that that's not true. So I don't think that making this a felony at all is going to deter anybody any more than it would be as a misdemeanor. So I feel much more comfortable with that.
I would prefer that change also. I mean, I'm not weighing in on the Well,
Well, we can have all kinds of arguments about the deterrence effect, but um, I will point out Vermont doesn't have a death penalty. Just to make clear.
I like to terrify and intimidate. I have to admit, I like this list. Well, maybe it needs some, I don't know if it needs to be clarified a little more or not.
Well, I think if you leave the current law the way it is in terms of the penalty, and you have the heightened penalty is 2 years instead of 3. So, and the fine, I don't care what the fine is. But I think you could raise the fine as long as whatever you do is consistent with C. So, you raise the fine in C on line 16 of page 1 to $2,000. And then you have for the heightened penalty 2 years and $2,000 or $5,000. I don't care what the number is.
Okay. 2 years and not more than 1,000.
You just have to be, I just think you have to be consistent with what we already provided for heightened penalty when you interfere with somebody reporting to the DCF.
Yeah. Okay.
Could I ask Ben a question?
Yep.
On that line right there?
19.
Well, on line 21, and I think it's in the others too, where it says that places any person in reasonable apprehension. But I know that you talked about an objective analysis there, but it says any person in reasonable apprehension. It doesn't say a reasonable person in reasonable apprehension. Is there a difference, or am I really splitting hairs here?
Well, I think with this, I think it might be more of a matter of splitting hairs to a degree.
Okay.
We can always craft the language to be a bit clear. If you want to put in any reasonable person in reasonable apprehension, it may be a tad redundant, because ultimately the analysis is that objective reasonableness.
It's the reasonable apprehension, but not the reasonableness of the person. But if that's splitting hairs, I'm okay. It just seemed to me that it should be a reasonable person that is in apprehension.
All right. I'm going to ask if there's any other. Ben, do you have enough to redraft?
I think I do. I just want to ask a couple clarifying points for the committee.
Sure. Yep.
So we mentioned as far as subsection C and D for those penalties to be aligned. So from my understanding of that, subsection D would be 2 years. And do we want to change the fine of $5,000 in D to match that of subsection C's $1,000, or do we want to?
No, I'd up both of them to 2,000 or 2,500, whatever the committee wants.
About 2,000.
So I'm hearing 2 years and $2,000.
Yep.
Okay.
I guess that's what they want.
The other clarification would be as far as the use of any federal, state, or municipal building in subsection D, and whether or not we want, the committee wants to include or exclude correctional facilities from that.
No, I don't want to exclude it. I don't want to exclude. I think if we're going to keep it the way it is, then we shouldn't exclude anything. If we're going down, we dropped the felony. I want to make clear that I was comfortable with the 3 or 5 years actually. So just so it's on the record that I didn't have a problem with the 3 or 5 years, but if we're going down to the misdemeanor, I don't see any reason to remove correctional facilities from the places of public accommodation.
Okay.
If we're going to use that standard, which I think we probably should, it's easier. And then we're going to use Mr. Thibault's language for
Yes, so for subsection H, the language of intent to terrify, intimidate, and then also to sort of enumerate the specific actions rather than keeping it broader to relative to the respective position. So it would read, a person who violates subsection A of this section with the intent to terrify, intimidate, or unlawfully influence the conduct of a public servant, election official, or public employee in any decision, opinion, recommendation, vote, or other exercise of discretion taken in capacity as public servant shall be in the penalty. Again, do we want to keep it consistent, 2 years and $2,000 for this provision?
Yep.
Okay.
That's, I think, what the committee was directing was Senator Nick and Senator White were clear, and I think Senator Benning hasn't spoken on that, but I think. So why don't you take that down now, and we'll just see if there's any further comments from any committee member or anybody in the room. Mr. Lawton.
Hey, good morning still it is, right? James
Still
Lawton again.
morning.
I gave testimony before. So I'm absorbing a lot here, but I want to ask a clarifying question. Are we talking about, or are you talking about bringing this down from a felony to a misdemeanor? Is that what I'm hearing? Okay.
Yes.
So with what we went through, I have scenarios for everything that we're talking about here. You know, like one of the things that Mr. Valerio mentioned and others have mentioned, that we have the laws already on the books to take care of this, take care of that. But part of the problem is that those aren't being. So for instance, Erica Marthage made a statement to the Burlington Free Press that she could have used the disturbing the peace by electronic means, okay, to try to stop Mr. Mish from continuing his activity. But she determined herself personally that she didn't feel like Kaya showed fear of Mr. Mish. And she did that without ever talking to Kaya. She made that decision on her own. And so that was taken out of our hands, or out of Kaya's hands, as a victim. And certainly, Dick, you were at the press conference, and if you saw the look on Kaya's face when he walked in the room, you know how afraid she was of him.
Mm-hmm.
It was only because she just shot back once on a Instagram and said, "What is your problem with me?" And of course, he told her that his problem was that she was a black woman, so she couldn't represent him as a white male. But in that same case with him, he has got, now he's worked his way up to 10 violations of probation, 10 misdemeanors, until he finally worked his way all the way up to a felony now. And so when you reduce it to a misdemeanor, people like him, it's not a deterrent. I mean, laws are not deterrents to people from breaking the law. It's punishment for breaking the law. That's the way I view it. Since he's not receiving any real punishment, he doesn't even have to pay a bail. He just goes out and does the same thing over and over and over and over again. Whereas if one of these things became a felony earlier on, it would have been a way to stop him from continuing the same activity for now going on how many years? I mean, he's literally going out there every day almost and creating more problems for
5 years.
Yeah, right. He's been able to go on for this long. So, you know, in talking about what Senator Benning brought up, like if he doesn't feel completely threatened himself, this law, I see it as a way of preventing, like you mentioned to me, Dick, and it made me think, long and hard about that this wouldn't have protected Jamal and I. But if there was intervention early enough, it would have protected us.
Mhm.
Because if there was intervention early enough to help Kaya, it would not have gotten down to us. It wouldn't have filtered down to us. Do you know what I mean?
Yep. Well, I
So-
think that,
Yeah.
that if I can, I think that changing the standards to more of the federal code would have allowed. You never know what a state's attorney's going to do, so I can't predict, and you never know what law enforcement is going to do to enforce the law.
Yeah.
But having the federal standard, I think, would make it easier for State Attorney Tebow to have charged
Mhm.
people in connection with the what happened in to the Secretary of State's office.
Yep.
Which would then allow, I think, you start to set standards, and hopefully in cases like yours, Jamal's and Kaya's, you would have state's attorneys who are willing. But we're just dealing with in Chittenden County, certain crimes are not being prosecuted.
Yeah.
The merchants there were upset about it, but it's really the state's attorney's choice not to prosecute. Still against the law to shoplift.
Yeah. 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 That's right. So I just want to be, early intervention could have, what these type of people do is if they are not ruffling your feathers enough, then that's when they start going down and attacking your family.
I think that the bill itself, in whether it's a misdemeanor or felony, changing the standards for Vermont to be more aligned with the federal will allow prosecutors more latitude.
I agree.
If they so choose.
Yeah. Yeah. We at least have to have laws as strong as what the federal has on the books. I agree.
So I, while I'm, I would have preferred a felony. I can, committee members are more comfortable at this point.
Mhm.
And I think just changing the law is what's more important. I see State Attorney Tebow has a comment.
So I just want to echo what Mr. Lawton said, that the court's discretion in terms of conditions or other responses for a felony offense is substantially greater than the case of a misdemeanor, which I think is known to the committee. Again, I would make again a pitch. I think having felony exposure for these carve-outs makes sense. I understand the concern about a correctional facility. I'm not sure that one category exception is necessarily worth sacrificing the ability to proceed that way. And I say this again, looking more to the collateral consequences, not because it's a deterrent, but because sometimes having a legal prohibition on someone acquiring a firearm after such a conviction or making a true threat in this context is important. The only other thing I'd note is just trying to rationalize our something we often try to do is look at, not just what are gaps in terms of what you can prosecute, but what are gaps in terms of the punitive response or supervisory response from the Department of Corrections. And I would note that the only difference here between making a true threat for a school shooting versus completing one would be then a 2-year misdemeanor versus, a substantial, I think, 20-year felony for our domestic terrorism statute. And having something to fill that gap, I think, is important. I want to note again that there are a lot of circumstances where we have a mixed set of both conduct and speech. We're not talking about the offenses which are, covered where there is actual conduct. So, for example, being armed and pointing it at somebody could be considered in their presence an aggravated assault with a deadly weapon, which is already a felony. I understand that this is different, but sometimes a true threat is one that is already a fairly high standard because of what the Constitution requires. And sometimes the only difference is time, proximity, and being intercepted before something worse is allowed to happen. And I'll just note again that earlier this session we haven't really talked about another incident. I don't want to get too much detail because it's an open case in my county, but we did have somebody show up with a firearm at the State House looking to see the Speaker of the House, and that's an area of significant concern, and that's where I think those are the type of situations that have us staying up late at night thinking about what to do and how to best protect public safety.
Mm-hmm. Thank you.
I just want to, if I can, this true threat threat thing, I know, I'm glad somebody brought up Slate Ridge because that's just been a mess for so long. But I guess I have issue when we're talking, like what I was talking about with, Erica Martha's making a decision on her own that Kyle wasn't feeling fear when she didn't talk to her. Too many, like, the officers themselves are starting to make these decisions on their own before they ever do anything about it. There was a situation with Slate Ridge where Mr. Bonnier threatened two young teenagers and their father, and he flat out told them he was going to shoot them and kill them where they stand. And the state trooper decided that it wasn't a true threat because he didn't have the gun in his hand when he made the threat. Now, he had the gun in his truck. He had access to it. He has access to hundreds and hundreds of guns of all sorts on his property. And yet, because he wasn't holding the gun in his hand, the state trooper himself decided that he wasn't going to take it any further because he deemed it not to be a true threat. So I don't know what kind of laws you can put in place that make people at the point of contact, take some of these things more seriously.
Mhm. Agreed. If we can get back to the committee, we've heard concern about dropping it to a misdemeanor. You still more comfortable with that? You're muted, Senator Nick.
Is that a question for us to answer?
Yeah, if you want to, I'm going to ask Ben, we're going to take a break, asking Ben to go back and redraft and get together, say at 11:15 or something like that, giving him an hour to redraft. So if he thinks he can do it in an hour. And then, but I want to make sure that we're all agreed that we have unanimity. I'm willing to go with a misdemeanor. I suggested it as a way to get us across the bridge. But if you're changing your mind based upon the testimony from Mr. Lawton and State Attorney Thibault, I'm happy to look at the 3-year misdemeanor. 3-year felony. No.
I'm okay where we're going, where I think we're going.
Okay.
I thought we were
All
going
right.
to a 2-year misdemeanor.
We are. I'd just say we had testimony
Right.
from 2 individuals concerned about that. So, Senator
I-
Benning,
Yeah,
Go ahead.
I certainly have no objection to moving to a misdemeanor. One of my other problems was that it was a felony we were creating.
I still think that it should be a misdemeanor, and I appreciate Mr. Lawton's testimony. But it seems to me that part of the issue here was not what the penalty was, but that the investigation and the way it was the current law was carried out was also contributed to it. So
Okay.
I'm still on a 2-year misdemeanor.
okay, can we get back together at 11:15? You can all go out, have a cup of coffee, you can run down to Dunkin' Donuts if you have one, or Starbucks if you're lucky enough.
So can I just ask a question not related to this?
Sure.
So
Yeah.
with the letter that, or whatever it is, we've received from Secretary Bloomer with regard to the judges, I guess.
Yeah.
Have we?
There's nothing this has been a problem.